Hi, this is Adam Stofsky with Briefly, and I'm here with Jordan Gustafson for our video series on family law issues. Today, we're going to talk about a really interesting topic and a kind of complex one of child support. We'll just start with a basic question, Jordan. What is child support?
Yes, so child support can be awarded in a variety of different ways through the court system, but essentially it's where the court is ordering one parent to pay support to another parent to ensure that the child is financially cared for.
When you say child, what does that mean? How long does this last? Is it forever?
So the support will last either until the child turns 18 or graduates high school. So it can go a little bit longer than 18 if the child is still enrolled and active in high school.
Got it. So who exactly can ask for child support?
So either parent can file for child support. The court would have to establish that the other party is actually the parent. So, depending on if this is a divorce or done through a parentage action, there's a few different ways. But so long as both parents have been determined to be the legal parents of the child, then support could be ordered against either of them.
So in the most common situations is when you have two parents who are just living apart for whatever reason, either they're divorced or never were together. That's usually when these situations come up, right?
Yes, that's exactly how it usually begins.
Okay. So how does the person who wants the support or is seeking this, how do they actually go about getting it?
Yeah. So, like I said, there's a few different options. One, the parent can go directly to the local Department of Child Support Services and open up a case through them. And the Department of Child Support Services will help locate the other parent, gather financial information, and kind of assist the parent through the case of requesting it. The other option is to do it through an open case with the court, either through divorce, a request for domestic violence restraining order, or if there has been a petition to establish parentage filed. So there's there's kind of a few different routes depending on the facts of the case.
So if the child support is a part of a larger divorce situation, usually it happens as part of that court process.
Yes, more often than not, that's the route that would normally happen. The exception to that is if the custodial parent is receiving public benefits, such as CalWorks from the government. The government can actually step in and initiate a case through the Department of Child Support Services, and they will initiate that case if the parent is receiving benefits on behalf of the children.
How do you determine how much child support is and who pays who? What is that based on?
There are a lot of factors, and there's actually a set calculation. It's beyond what I could explain in the mathematics realm, but luckily there is a software program that the courts and parties can use to input the information. But the primary factors are going to be the visitation schedule. So, what percentage of time the children are spending with each parent, and then the income of each parent. And there are also factors they'll look at, such as how much is a parent paying in healthcare each month, or if there's mandatory retirement dues that have to be paid, union dues. So it'll feel a little bit like doing your taxes and looking at all the deductions, but all that information will be put into the software program and that will generate a number of what child support should be.
Can you agree to child support with the child's other parent without going through this process?
Yes, under certain circumstances, if the parties do agree, the parties are free to file what's called a stipulation with the court that sets forth what the child support should be. However, when the court is looking at support, it's actually the child's right to receive support, not the parent. So they will still run that guideline calculation and figure out what the guidelines support should be, and then compare that to what was agreed upon by the parents. And the parents may need to show that if the support's below guideline, why they're agreeing to that, and that the children will still be sufficiently cared for, even though that support amount is lower. So it
Okay.
can be done, but sometimes a little additional showing is required to make sure the children are being cared for appropriately.
Once there's an order, so the court will order, hey, parent A has to pay child support to parent B in X amount of dollars. How does parent B actually get that child support?
Yes, is often that can often be the harder issue than getting the support itself. Enforcement is definitely a big area when it comes to child support. And we often recommend at that point of registering the order with the Department of Child Support Services because they can help facilitate getting wage garnishments. They can even sometimes pull from tax returns if the parties aren't paying. There's a few different avenues um, that a party can take if they're not receiving their support. But the primary is if the parties are cooperating, they can just directly pay to each other, or they can file a wage garnishment, which will pull the money directly from the other party's paycheck before they receive it. So that ensures that the money is not being spent elsewhere. And then that money would essentially be registered with Department of Child Support Services, who would then make the payment to the custodial parent. So it's kind of the safest way to make sure that that money is being secured before it can be spent elsewhere.
What happens if a parent needs to change the child support? Like, what if you lose your job, or maybe you get, I don't know, you get deployed in the military, or like you have other kids. I don't know. There's like a million things that can come up, right? How can you change it?
Yes, child support, it can always be modified if there's been a change in circumstances. Like, as you suggested, if a party loses their job, or maybe they even took a new job and got a significant wage increase, and the other party wants to increase support.
Oh,
Um,
the other parent can say, hey, you've got to start paying more now. Oh, interesting.
yes, either party can request a change whenever there's been a change in circumstances, and that would just essentially new income information would be filed with the court. The court could rerun the numbers, and that change could be made. Now, there are factors that the court will also consider. For example, if a party voluntarily quits their job to avoid paying support, there are factors that can come into play to order that party to seek work, or if a party is deliberately working below maybe their education level or what they have in the past, there are things that the court may address. So it's not something where you could just quit your job and, oh, I don't have to pay support anymore. So there's,
That was my next question, actually. What happens if someone says, you know what, forget this, I'm going to go move to Maui and surf for the rest of my life and live on the beach? I guess the court can say, you really can't do that.
yes, they can definitely look at those factors. And what will often happen is they will give the party a certain amount of time and to look for work. They may have to show the court, here's a list of applications that I've filed. This is how I've tried to obtain work. Or maybe here's a doctor's note. This is why I'm not working. This is why I'm on leave. So they will have the opportunity to justify not working. But if there is no reason and no effort to obtain work, the court will do what's called imputing wages. And they will say, based on your work history, your education history, you have the ability to earn this much money. And they will use that amount for determining support and still make those orders. And you'll just start accruing what the court calls arrears. And the balance that you owe will just continue to grow until the payments start being made.
This lasts as long as the child is legally a child, right? Until they basically until they're 18, or a few other situations, right? What was the other one when they go when they finish
Graduate high school.
high school? So can you let's say I never saw child support, and now the kid is 16. My divorce happened when the kid was 8. Can I go and get like 8 years of back child support?
No, there with the law, there's always some exceptions, but generally speaking, the furthest they can go back is to the date that a request for order was filed. So if the person's actively evading service, or, there's some issues where they're just not participating in the case, orders can be made, but only as far back as when the party affirmatively sought support.
So if you're seeking support, like, you want to file it as soon as possible.
Yes, definitely. That is the best course of action. You cannot recoup those years that you did not have a case open.
Is this the kind of thing that folks can do without a lawyer? Or do you need a lawyer to do this?
We always advise seeking legal advice when possible, but through the Department of Child Support Services, an attorney is assigned to your case. The attorney does not represent either party, but in a sense represents the children's interest in receiving that support, is kind of one way to explain it. And that attorney will guide the case along and ensure that orders are made. So that's why we often recommend Department of Child Support Services to those parties who can't afford an attorney, because there is that government attorney at least kind of guiding the process and helping it get to where it needs to be.
And how can Inland County's legal services help?
Yes, we for those who qualify for our services, we can help with modification or, even filing the petition for parentage, the petition for divorce, kind of helping open that initial case that opens the door to being able to request those support orders.
Okay, great. Jordan, thank you so much.